Hi, I'm Steve Patton, President of HCM Property Management, and welcome to this week's episode of the Property Management Minute. Hello and welcome. In this episode, we're going to talk about California's new rent control law, which went into effect on September 1st, 2019, titled AB 1482. So in the past, as you may know, most of the rent control laws were applicable to local communities or municipalities. This is different. It applies to all of California. So whether you own a rental property in LA or Orange County, this law could have dramatic impact for you. There are a few key details you're going to want to know about this law to stay in compliance. And also know that this law does not override any existing rent control provisions that you may have on your investment property. So the best way to look at this law is to break it down into three distinct questions. Number one, is my property included in the new law? Number two, what are the rules surrounding rental rate increases? And number three, what are the termination of tenancy requirements that are stipulated under the new law? So let's quickly go over to find out if your property may or may not be included in this new rent control law. So there's really a few things to look at. Number one is, what's the age of your property? Number two, what type of investment property do you own? Is it a single family home, a condo, multifamily apartment? And third, are you a private real estate investor or are you a corporate sponsored real estate investor? As far as the age of your property is concerned, the key takeaway here is 15 years. The law applies to any property that has not been issued a certificate of occupancy in the most recent 15 years. So in other words, if your property is 15 or more years old, this law could apply to you. And the key thing to keep in mind here too is it's a rolling 15 years. So as of now, this could apply to properties built in 2004 or earlier, but next year it would then apply to properties built in 2005 or earlier. Now, the law substantially excludes single family dwellings and condos. It's primarily there to address multifamily homes and apartment complexes. So the law technically says that residential real property that is alienable separate from the title to any other dwelling unit provided that both of the following apply. Now here's where it goes into what type of owner are you? Are you a private owner or are you a corporate sponsored owner? And so with respect to ownership criteria, this doesn't apply to you if the owner of the real estate is A, not a real estate investment trust, B, a corporation, or C, a limited liability company in which at least one of the members is not a corporation. So in other words, they're really trying to focus on the corporate-owned landlords, not individual investors. Now, if you believe that your property is not subject to the new law, you still have to provide a notice to the tenants that your property is not subject to it. So in other words, you can't just say, it doesn't apply to me. So you need to then provide in writing to your tenants that this property is not subject to the new Senate bill or the new Assembly bill that applies to the rent control provisions. Now, we'll attach a link at the bottom of the notes here so that you can actually go and read the text of the law yourself. Now, there's also a few other carve-out provisions that you're going to want to read about. For instance, if you own a duplex and you live in one of the units, that's exempt. College dormitories are exempt. Room rentals are exempt. So there's a lot of details to it that we can't get into here. So I strongly urge you to speak to your attorney about it or to go ahead and read the text of the law. So now let's address termination of tenancy requirements. In the past, if you were coming to the end of a lease and you just didn't want to renew that particular tenant for any reason, you didn't have to. You provide proper notice, you don't have to renew them. Now, under the new law, the big focus is just cause termination of tenancy. So the just cause termination of tenancy is really broken down into two categories. The first is at fault, and the other is no fault. An at fault sort of provision would be non-payment of rent, material breach of the lease, illegal activity at the property. certainly within our rights to evict a tenant that is in breach for those reasons. No fault would be things like an owner wants to move back into the property, or you've acquired a property and you want to demolish it to rebuild something, or you want to substantially rehabilitate the property, or you're subject to any sort of government or court mandate to do something with the property. Important thing to keep in mind under the no-fault provision, if you choose to enact that, you then be responsible for relocation of that tenant up to the amount of 1 month's rent.